Hello everyone, welcome to ClearIAS. In this video, we will be discussing about non-constitutional bodies. I am Ujjwala Pulala, an educator at ClearIAS. So firstly, what are non-constitutional bodies? They are also known as extra-constitutional bodies. These are not defined in the constitution of the country. Non-constitutional bodies are formed either through parliamentary statute or an executive resolution. They are formed as per the requirements of the country. The first one is National Human Rights Commission. NHRC is a statutory body, that is, it is formed through an act, and the act is Protection of Human Rights Act 1993. It is considered as the watchdog of human rights in the country. Composition. The commission consists of a chairman and 4 other members. The chairman should be a retired Chief Justice of India. The other members should be serving or retired judges of the Supreme Court, a serving or retired Chief Justice of a High Court, and 2 persons with special knowledge or practical experience related to human rights. The Commission has the following ex officio members. So, ex officio members are those who become the members of NHRC by virtue of their position. They are not appointed separately. So, these are the chairman of the following bodies, that is National Commission for Minorities, National Commission for SCs, National Commission for STs, National Commission for Women, National Commission for Backward Classes, National Commission for Protection of Child Rights, and the Chief Commissioner for Persons with Disabilities. Appointment. The chairman and members are appointed by the President on the recommendations of a 6-member committee consisting of Prime Minister, Speaker of the Lok Sabha, Deputy Chairman of Rajya Sabha, leaders of the opposition in both houses of Parliament, and Central Home Minister. Term of office. The chairman and members hold the office for a term of 5 years or until they attain the age of 70 years, whichever is earlier. After the completion of their tenure, they are not eligible for further employment in central or state government. Removal from service. The chairman or the members can be removed by the president under the following circumstances: if he is adjudged and insolvent, if he engages in any other paid employment, if he becomes unfit by reason of infirmity of body or mind, if a competent court declares him to be of unsound mind, if he is sentenced to imprisonment for an offence. Other than the above reasons, the President can remove them on grounds of proved misbehavior or incapacity. But in this case, the President has to refer this matter to SC for inquiry. Functions. To inquire into any violation of human rights or negligence in the prevention of such violence by a public servant. To visit jails and detention places and study the living conditions there. To review the various safeguards provided for the protection of human rights. To intervene in any proceedings before the court. To study the various international treaties and instruments. To promote research in the field of human rights. To promote literacy about human rights among the people. To encourage the efforts of NGOs working in the field of human rights. State Human Rights Commission. So the same act, that is the Protection of Human Rights Act of 1993, provides for the creation of a State Human Rights Commission. With respect to the subjects mentioned in State List and Concurrent List, SHRC has the authority to inquire into violations of human rights. So as we all know that the 7th schedule of the Constitution divides the subjects into 3 lists: Central List, State List and Concurrent List. So with respect to the subjects mentioned in State List and Concurrent List, SHRC has the authority of inquiry. Composition. . SHRC consists of a chairperson and 2 other members. The chairperson of SHRC should be retired Chief Justice of High Court. The members should be serving or retired judge of HC or a district court having minimum experience of 7 years and a person with knowledge or practical experience in human rights. Appointment. The chairperson and the members are appointed by the governor. The appointment is made based on the recommendations of the committee consisting of the following members: Chief Minister as its head, Speaker of the Legislative Assembly, State Home Minister, Leader of Opposition in the Assembly. In the case of bicameral legislature, that is consisting of both Assembly as well as Council, the Chairman of Legislative Council and the Leader of Opposition in the Council will also be members of the committee. Term of office. The chairperson and the members hold office for a period of 5 years or until they attain the age of 70 years, whichever is earlier. The chairperson and the members are not eligible for further employment under a state or central government. Removal from service. The chairman or the members can be removed by the president under the following circumstances. So, although they are appointed by the governor, they can be removed only by the president. If he is adjudged and insolvent, if he engages in any other paid employment, if he becomes unfit by reason of infirmity of body or mind, if a competent court declares him to be of unsound mind, if he is sentenced to imprisonment for an offence. Other than the above reasons, the president can remove them on grounds of proved misbehavior or incapacity, and in this case, the president has to refer the matter to SC for enquiry. Functions. The functions of SHRC and NHRC are similar. To inquire into any violation of human rights or negligence in the prevention of such violence by a public servant. To visit jails and detention places. To review the various safeguards provided for the protection of human rights. To intervene in any proceedings before the court. To study the various international treaties and instruments. To promote research in the field of human rights. To promote literacy about human rights among the people. To encourage the efforts of NGOs. Central Information Commission. The Central Information Commission was constituted through an official Gazette notification under the Right to Information Act 2005. The complaints and appeals related to the officers, financial institutions, PSUs, etc. under the central government and union territories are looked after by the CIC. Composition. It consists of a Chief Information Commissioner and not more than 10 Information Commissioners. They are appointed by the President based on the recommendations of a committee consisting of Prime Minister as Chairperson, Leader of Opposition in the Lok Sabha, Union Cabinet Minister nominated by PM. So you have to remember the members of the committees related to various bodies. So as we have seen in the case of NHRC, the Central Home Minister is considered to be a member of the committee, whereas here in the case of CIC, any Union Cabinet Minister who is nominated by PM is eligible to be the member of the committee. Tenure of Service. They hold office for a term of 5 years or until they attain the age of 65 years, whichever is earlier. The Chief Information Commissioner is not eligible for reappointment. However, the Information Commissioner is eligible to be appointed as CIC with his term not exceeding 5 years, including his tenure as an Information Commissioner. Removal from service. The CIC and other Information Commissioners can be removed by the President under the following circumstances. If he is adjudged and insolvent, if he gets convicted of an offence involving moral turpitude, if he engages in any other paid employment, if he gets unfit due to infirmity of mind or body, if he acquires any financial or other interest prejudicing his official functions. The President can also remove them on the grounds of proved misbehavior and incapacity. Powers and functions. The Commission inquires the complaints from a person who couldn't submit an information request due to non-appointment of public information officer, who has been refused the requested information, who has not received response to his request, who thinks the charge fees to be unreasonable, who thinks the information to be incomplete, misleading or false, and any other matter regarding the information. The Commission has the suo motu power of inquiry. It has the powers of a civil court. The Commission submits an annual report to the central government which places it before each house of the Parliament. State Information Commission. The Right to Information Act of 2005 provides for the creation of a State Information Commission. The complaints and appeals related to the offices, financial institutions, PSUs, etc. under the state government are looked after by the State Information Commission. Composition. The Commission consists of State Chief Information Commissioner and not more than 10 State Information Commissioners. They are appointed by the Governor based on the recommendations of a committee consisting of the following members: Chief Minister as the chairperson, Leader of Opposition in the State Legislative Assembly, and State Cabinet Minister nominated by Chief Minister. Tenure of Service. They hold office for a term of 5 years or until they attain the age of 65 years, whichever is earlier. The State Chief Information Commissioner is not eligible for reappointment. However, the State Information Commissioner is eligible to be appointed as Chief Information Commissioner with his term not exceeding 5 years, including the tenure as Information Commissioner. Removal from service. The State CIC and other State Information Commissioners can be removed by the Governor under the following circumstances. So, in the case of State Information Commission, the appointment as well as the removal is done by the Governor himself. If he is adjudged and insolvent, if he gets convicted of an offence involving moral turpitude, if he engages in any other paid employment, if he gets unfit due to infirmity of mind or body, if he acquires any financial and other interest prejudicing his official functions, the Governor can also remove them on the grounds of proved misbehavior or incapacity. In this case, the Governor has to refer the matter to the Supreme Court. Powers and functions. The powers and functions of the Central Information Commission as well as the State Information Commission are similar. The Commission inquires the complaints from a person who couldn't submit an information request due to non-appointment of public information officer, who has been refused the requested information, who has not received response to his request, who thinks the charged fees to be unreasonable, who thinks the information to be incomplete, misleading, or false. Any other matter regarding the information. The Commission has the suo motu power of inquiry. It has the powers of a civil court. The Commission submits an annual report to the state government which places it before the state legislature. Central Vigilance Commission. CVC is concerned with preventing corruption in the central government. It was established based on the recommendations of the Santanam Committee on Prevention of Corruption. Initially, CVC was established through an executive resolution in 1964. Later in 2003, CVC was conferred the status of a statutory body. Composition. CVC consists of a Central Vigilance Commissioner and not more than 2 Vigilance Commissioners. They are appointed by the President by warrant under his hand and seal. It means President authorizes the appointment of CVC through his signature as well as seal. He does not delegate this function. They are appointed based on the recommendations of a committee consisting of Prime Minister as head, Union Home Minister, and Leader of Opposition in the Lok Sabha. Tenure of Service. The chairperson and members of the Commission hold office for a term of 4 years or until they attain the age of 65 years, whichever is earlier. They are not eligible for further employment either under the central or state governments. Removal from service. They can be removed by the President under the following circumstances: if he is adjudged and insolvent, if he gets convicted of an offence involving moral turpitude, if he engages in any other paid employment, if he gets unfit by reason of infirmity of mind or body, if he acquires any financial and other interest prejudicing his official functions. The President can also remove them on grounds of proved misbehavior or incapacity. Functions. To inquire or investigate into the allegations that a public servant has committed an offence under the Prevention of Corruption Act 1988. To exercise superintendence over the Delhi Special Police Establishment concerning investigation of offences under the Prevention of Corruption Act of 1988. To give directions and review the progress made by the Delhi Special Police Establishment concerning such investigation. To advise central government and exercise superintendence over the vigilance administration of its authorities. Regarding the vigilance and disciplinary matters relating to the members of central services and All India services, CBC is to be consulted by the government. To inquire or investigate offences under the Prevention of Corruption Act 1988 concerning the members of All India services, Group A officers and other specified level of authorities in central government. Working. CBC has all the powers of a civil court and it regulates its own procedure. Its proceedings are conducted at its headquarters in New Delhi. CBC presents a report on its performance to the President annually, who places it before each House of Parliament. Central Bureau of Investigation. CBI is set up in 1963 through an executive resolution. The establishment of CBI was made on the recommendations of Santanam Committee on Prevention of Corruption. The powers of CBI are derived from the Delhi Special Police Establishment Act of 1946. It is the main investigating agency of the central government. Composition. The CBI is headed by a director who is assisted by a special director or an additional director. It also consists of a number of joint directors, deputy inspector generals, SPs and other police personnel. The director has a security of tenure of 2 years by the CBC Act of 2003. The director acting as the Inspector General of Police, Delhi Special Police Establishment, is responsible for its administration. Functions. To investigate the cases of corruption, bribery and misconduct of the employees of central government. To maintain crime statistics and to disseminate such information. To investigate crimes having national and international ramifications. To coordinate with other anti-corruption agencies and state police services. To investigate the cases dealing with the fiscal and economic laws. Lokpal and Lokayuktas. One of the many institutional devices to redress the grievances of citizens against the administration is the Ombudsman system. Ombud refers to a person who acts as a representative of another person, and this institution was first created in Sweden in 1809. Since then, such ombudsman-like institutions were adopted by more than 40 countries like Finland, Denmark, Norway, New Zealand, UK, etc. To redress the citizens' grievances, the institutions of Lokpal and Lokayukta were recommended by the Administrative Reforms Commission. Lokpal was to deal with complaints against ministers and secretaries at central and state levels. Lokayukta, one at the center and one in every state, to be formed to deal with the complaints against other higher officials. Lokpal and Lokayuktas Act of 2013. Establishment of Lokpal at the center and Lokayukta in every state. The Lokpal should consist of a chairperson and maximum of 8 members. 50% of members should be judicial members. 50% should belong to SCs, STs, OBCs, minorities and women, thus providing a chance for every section to get representation. The chairperson and members are to be selected through a selection committee consisting of the PM, Speaker of Lok Sabha, Chief Justice of India or a sitting judge of Supreme Court and an eminent jurist. The selection committee will be assisted by a search committee of which 50% members will be from SCs, STs, OBCs, minorities and women. The Prime Minister has been brought under the ambit of the Lokpal. Clear timelines are laid down for inquiry and investigation. Provision of adequate protection for honest public servants. Drawbacks. No authority of suo motu action against public servants. That is, the Lokpal cannot act on its own without receiving any complaints. Heavy punishments for false complaints. not allowing anonymous complaints. This is one of the major drawbacks because the provision for remaining anonymous can actually encourage the filing of complaints, limiting the period of filing complaints to 7 years. Lokayuktas. The institution of Lokayukta was first established in Maharashtra in 1971. The structure and functions of Lokayuktas vary from state to state. The Lokayukta submits a report on its performance to the governor annually. The recommendations made by Lokayukta are only advisory in nature and are not binding. NITI Aayog. NITI stands for National Institution for Transforming India, and NITI Aayog was established replacing the Planning Commission. It was established through an executive resolution. NITI Aayog's policy is driven by a bottom-up approach instead of the traditional top-down approach, and it provides technical advice to center as well as states. It is built on the principle of cooperative federalism. Composition. NITI Aayog consists of the Prime Minister as the chairperson, Governing Council comprising of Chief Ministers of all the states, Chief Ministers of Union Territories with legislatures, and Lieutenant Governors of remaining UTs. Regional councils to address specific issues or contingencies convened by PM and comprising of Chief Ministers and Lieutenant Governors. Special invitees comprising of specialists with domain knowledge. Full-time organization comprising of Vice Chairperson, full-time and part-time members, ex officio members, and a Chief Executive Officer. Objectives: to help in formulating plans at ground level and aggregating them at higher levels. To promote the spirit of cooperative federalism. To encourage the active participation of states in evolving a shared vision for achieving the national objectives. To formulate policies and initiatives and to monitor their progress as well as efficacy. To encourage partnerships with think tanks and policy research institutions. To provide a platform for resolution of interdepartmental and intersectoral issues. To undertake all such activities necessary to further the agenda of national development. To focus on technology upgradation required for the implementation of various initiatives. So that's all for today. See you all with another video. Thank you, and please subscribe to our channel ClearIAS and press the bell icon. Have a nice day.